This is part 62 and the last part as far as Indian Penal Code is concerned. In this part, we shall be dealing with chapter 21 of the Indian Penal Code, which deals with defamation. And in order to understand this, we shall start right from section 499 up to section 502 of the Indian Penal Code. As usual, as it was told regarding arrangements of the sections in the Indian Penal Code, 499 defines the offence of defamation. 500, 501 and 502 are the sections which deal with punishment. Now, if A defames Mr. B, the remedy which is available to Mr. B is to proceed as per the criminal law, where he can proceed as for saying that he has committed the offence of defamation, or he can go to the civil court and sue for compensation, where he can claim unliquidated damages, where when you will deal with law of torts, as in case if you remember when we dealt with trespass, we classified trespass under two heads: civil trespass and criminal trespass. In case of defamation, when you will deal with law of torts, you will come to know if somebody harms the reputation of somebody, he may be liable depending upon whether it is done orally or whether it is done in writing or in any other form, whether it will amount to a libel or slander. But there is a provision that you can go to the civil court and claim unliquidated damages as far as civil law is concerned, namely law of torts is concerned. Now here, as this being the last lecture, let me tell you, during course of time, I have tried my best to explain everything. But if at all you have any problem, you have any difficulty, or you have any suggestion, so that I should take some more lectures as far as this subject is concerned, by all means you can mail me. My email ID is prof.harish.deshmukh@gmail.com. So you write to me, you mail me, and then I will respond immediately without any problem. And don't hesitate to write to me. prof.harish.deshmukh@gmail.com. That is, we can be in communication with each other as far as this email ID is concerned. With this, now, if you start reading section 499, you have to read section 499, and from my point of view, most lengthy section. First of all, because of definition. 2. There are 4 explanations, and not only that, there are 10 exceptions. And then, unless you know the entire, namely you know the ingredients, you know the explanations, and you know the exception, you can't understand section 499 of the Indian Penal Code. And now if you start reading, it says, whoever by words either spoken or intended to be read, or by signs or by visible representations. So the offence of defamation can be committed by any one of the ways which are enumerated, namely it may be by words which are spoken, it may be by words which are intended to be read, which means written, it may be by signs, you draw a picture, you draw a cartoon accordingly, or it may be by visible representation. Somebody asks you how is that person, and you show a sign that, well, something is wrong with his brain. That is gesture on your part. And hence you say, well, something is wrong, something gone case at all. In that case, for example, it is what is known as visible representation. So what he does by these words, one who makes or publishes any imputation, he makes or publishes any imputation concerning any person intending to harm. What is the intention? Intention is to harm. Knowing or having reason to believe. Reason to believe has got reference as far as section 26 of the Indian Penal Code is concerned, with which you are dealt in the past. Or having reason to believe that such imputation will harm the reputation of such person, such imputation will harm the reputation of such person, is said except in the cases hereinafter accepted to defame that person. So if the words which are spoken, the words which are intended to be read, or by signs or visible representation, if somebody makes or publishes any imputation concerning any person, intending or knowing it to be likely that knowing it to be likely, or knowing or having reason to believe that such imputation will harm the person's reputation, is said except in the cases hereinafter accepted to defame that person. Now, which imputation will harm the person's reputation and which imputation will not harm the person's reputation? For that, you have to refer to fourth explanation, which says no imputation. No imputation is said to harm a person's reputation unless that imputation, directly or indirectly, in the estimation of others, lowers the moral or intellectual character of that person, or lowers the character of that person in respect of his caste or his calling, or lowers the credit of that person, or causes it to be believed that the body of that person is in some loathsome state, or in a state generally considered as disgraceful. So when you can say imputation will harm, it is in the negative form. It says no imputation is said to harm person's reputation unless that imputation directly or indirectly, in the estimation of others, lowers the moral or intellectual character of that person, or lowers the character of that person in respect of his caste or calling, or lowers the credit of that person, or causes it to be believed that the body of that person is in some loathsome state, or in a state generally considered as disgraceful. So that is as far as which imputation will harm the person's reputation and which imputation will not harm the person's reputation, made clear as far as explanation 4 to section 499 is concerned. Now, at times you may speak ironically, so it conveys two meaning, and you are liable for the offense of defamation because of third explanation, which says an imputation in the form of an alternative or expressed ironically may amount to defamation. So this is also, then it said, is it necessary that you should always defame a person? The answer is in the negative because of second explanation, which says it may amount to defamation to make an imputation concerning a company or an association or collection of persons as such. So it says it may amount to defamation to make an imputation concerning a company or an association or collection of persons as such. So there you can defame a group of the persons accordingly. Now, can you commit the offense of defamation by making imputation with respect to a person who is not in this world is made clear as far as first explanation is concerned, and it says it may amount to defamation to impute anything to a deceased person if the imputation would harm the reputation of that person if living and is intended to be hurtful to the feelings of his family or other near relatives. And then, as we talk about what do you mean by reputation? What the world thinks about you, and hence what is required? Makes or publishes. If you merely directly talk to the person and say you are dishonest, you are corrupt, you are not efficient, directly tell him, that won't amount to defamation, because this is required to be made known to the world at large, not to the world at large, but somebody other than the person with respect to whom it is made. So this is making or publishes any imputation. At times you give a news in the newspaper. So the one who has given a newspaper makes imputation, and one who has published in the newspaper is the publisher thereof. Both of them are liable as per the provisions as far as the offense of defamation dealt by section 499 of the Indian Penal Code is concerned. With this now, except in the cases hereinafter accepted to defame that person. So now if the person is accused of the offense of defamation, and if he can prove that his case falls under any one of the exceptions, and how many exceptions are there? There are 10 exceptions which are laid down as far as this section is concerned. I mean, I am not going through it, will be very lengthy. Otherwise, I mean, you just, I mean, go through the illustrations, no problem, and that will serve the purpose. If I mean, I show you the direction, I show you the way in which you have to proceed, that will serve the purpose. Out of these 10 exceptions, let me tell you, first exception and the fourth exception makes it very clear that truth can be only defense. Whereas the rest of the exceptions, they are defense provided, I mean, they are all the exception that is made in good faith, otherwise not. It's not necessary that it should be true or truth is the defense, but then this is required to be made in good faith. Now the first exception says imputation of truth which public good requires to be made or published, and it says it is not defamation to impute anything which is true concerning any person if it is for the public good, that the imputation should be made or published. Whether or not it is for the public good is a question of fact. So that will depend upon facts of the particular case. Second exception says public conduct of public servant, and says it is not defamation to express in good faith any opinion whatever respecting the conduct of a public servant in the discharge of his public function or respecting his character so far as his character appears in that conduct and no further. That is second exception. Third exception, conduct of any person touching any public question, and it says it is not defamation to express in good faith any opinion whatever respecting the conduct of any person touching any public question and respecting his character so far as his character appears in that conduct and no further. Fourth exception says publication of reports of the proceedings of court, and says it is not defamation to publish a substantially true report of the proceedings of a court of justice or of the result of any such proceedings. And the explanation says a justice of the peace or the other officer holding an inquiry in open court preliminary to a trial in a court of justice is a court within the meaning of the above section. Fifth exception says merits of a case decided in a court or conduct of witnesses and others concerned. It says it is not defamation to express in good faith any opinion whatever respecting the merits of any case, civil or criminal, which has been decided by a court of justice, or respecting the conduct of any person as a party, witness or agent in any such case, or respecting the character of such person as far as his character appears in that conduct and no further. Sixth exception says merits of public performance, and says it is not defamation to express in good faith any opinion respecting the merits of any performance which its author has submitted to the judgment of the public, or respecting the character of the author so far as his character appears in such performance and no further. And the explanation to this exception makes it very clear. It says a performance may be submitted to the judgment of the public expressly or by acts on the part of the author which imply such submission to the judgment of the public. With this now, the seventh exception says censure passed in good faith by a person having lawful authority over another, and says it is not defamation in a person having over another any authority either conferred by the law or arising out of lawful contract made with that person to pass in good faith any censure or the conduct of that other in matters to which such lawful authority relates. The exception says accusation preferred in good faith to authorized person, and says it is not defamation to prefer in good faith an accusation against any person to any of those who have lawful authority over that person with respect to the subject matter of accusation. The ninth exception says imputation made in good faith by person for protection of his or others' interest, and says it is not defamation to make an imputation on character of another, provided that the imputation be made in good faith for the protection of the interest of the person making it or of any other person or for the public good. With this, the last exception, namely 10th exception, says caution intended for good of person to whom conveyed or for public good, and says it is not defamation to convey a caution in good faith to some person against another, provided that such caution be intended for the good of the person to whom it is conveyed or of some person in whom such person is interested or for the public good. And then, in order to understand these exceptions which are laid down everywhere, barring only two exceptions, namely first exception and fourth exception, you must have realized that unless it is made in good faith. And what is good faith? It says section, you have to have reference to section 52, which says nothing is said to be done or believed in good faith which is done or believed without due care and attention. Whereas in a case, I refer to one, we have, while dealing with the section, we have come across a term reason to believe, and if you read section 26, it says person is said to have a reason to believe a thing if he has got sufficient cause to believe that thing, but not otherwise. Now, when you are talking about the book which is written by anybody, A may say book is good, B may say book is bad, or I don't like the book. Both of them must make this statement or imputation in good faith. In other words, both of them must have read the book, they must know the language in which it is written. Or when you talk about any public performance, you must witness the public performance. You have got, if you go through as far as the proceedings of the court are concerned, everybody has got right to know what is going on in a court of law. And it is because of this right that everybody has got faith and confidence in the system of administration of justice which is prevailing in the country. So there you can by all means report true proceeding, but then you can't add of your own. So this is fourth exception. Or in case of fifth exception, once the decision is given by the court, maybe Supreme Court also, you may agree with the decision or you may not agree. You have got every right to criticize the decision. But in order to criticize the judgment which is delivered by any one of the courts, and mind well, you cannot criticize as long as the matter is not finally decided, because that amounts to contempt of court. But once the decision is given by the Supreme Court, or at least when the period of limitation expires, that you can't go to the Supreme Court, and the decision is given by the High Court, you can by all means have comment with respect to the merits as far as that case is concerned. But for that, unless you read it, it's not that somebody says and you have done it, because it is required merits of a case decided in a court or conduct of witness and other concern, and it is required to be made in good faith. So, understanding of good faith, whichever may be the exception, as you go through the illustrations, you will find out. It's not necessary for me to deal with, or as you have come to know, in order to understand the offense of defamation, you have to first of all read section 499. You have to read the four explanations, and if the case each is subject to exception, if the case falls under any one of the exceptions which are dealt, and there are 10 exceptions, the person is not at all liable for the offense of defamation as far as section 499 of the Indian Penal Code is concerned. If person commits the offense of defamation, then punishment for defamation as laid down by section 500, which says whoever defames another shall be punished with simple imprisonment for a term which may extend to 2 years, or with fine, or with both. As far as section 501 is concerned, it says printing or engraving matter known to be defamatory, and says whoever prints or engraves any matter knowing or having good reason to believe that such matter is defamatory of any person shall be punished with imprisonment for a term which may extend to 2 years or with fine or with both. And the last section, section 502, deals with sale of printed or engraved substance containing defamatory matter, and says whoever sells or offers for sale any matter or engraved substance containing defamatory matter knowing that the contains such matter shall be punished with simple imprisonment for a term which may extend to 2 years or with fine or with both. Though I have dealt with the sections dealing with punishment, in general I have told you that, well, do you have to concentrate when you come across such a situation? It's alright, but otherwise concentrate on that particular section of the Indian Penal Code which defines an act which amounts to an offence. With this now, the provisions regarding Indian Penal Code, we started discussing right from section 1 and came up to section 511 of the Indian Penal Code during the course of time, and now this is the end as far as our series of lectures dealing with the provisions of the Indian Penal Code is concerned. Thank you very much.